My name is Tim Seymour, and I'm the Assistant Manager for the Groundwater section at the Oregon Water Resources Department. Today, I'll be presenting on the department's update to the Division 10 Critical Groundwater Area Designation Rules. In previous informational sessions, we've shown this slide before, and it shows the different regulatory groundwater control tools that the department has for managing water within the state of Oregon. The tool, as I said, that we'll be talking about today is the Critical Groundwater Area Designation, which is focused primarily on controlling current groundwater use. So this tool affects current groundwater right holders and potentially exempt users. It does not look forward like many of the other tools. So as we've discussed previously, we have withdrawal of unappropriated waters and classification of water, which is focused on future new groundwater use. The serious water management problem area, which is focused on measuring and reporting of water use. And then we have the groundwater mitigation area, which is currently only affects the Deschutes Basin, and again, is focused on future groundwater use. A couple of other tools that we have are permit condition regulation. This is where the department would regulate to the specific conditions within a permit. Oftentimes these are related to water level declines. So if water levels decline beyond a certain point from a reference level that's set, then that use of that well could be regulated off. And the last tool is actually a voluntary tool. And this tool can be used in coordination with any of the other tools. And it's an agreement between groundwater users within the same groundwater system to specify how groundwater will be used. And that tool pairs nicely with the critical groundwater area in that it controls present use as well. So a voluntary agreement could be used alongside a critical groundwater area to allow for voluntary management of water as opposed to regulatory management of water use. So next, I'm going to talk about why a rulemaking update was needed for the Division 10 rules. So the administrative rules currently do not match the current statute. So the statute for critical groundwater area designation was last updated in 1991, and the current rules that are on the books were last updated in 1990. So the two are out of sync and need to be brought into compliance with each other. The second piece is that the proposed Division 10 rules are going to help clarify some statutory terms and processes within the current critical groundwater area statutes. So there were some key differences between the old rules and the new rules, and the statutes changed back in 1991, and those changes were pretty substantial. So in the old rules, the critical groundwater area was designated by the state engineer through an order. And it did not contain a process for a contested case hearing. So in the previous rules, the department and the state engineer could simply designate a portion of the state as a critical groundwater area. In the new rules, which comply with the new statutes, the critical groundwater area has to be designated by the commission via rule adoption. And these statutes and these rules will now contain a process for contested case hearings. And that contested case hearing is what allows groundwater right holders and exempt users to be provided due process if use limitations are going to be proposed. So the new rules provide substantially more time for public input on the designation and then provide those due process protections in the form of a contested case hearing. So now this slide is talking about the rulemaking timeline. This is specific to the Division 10 rules. We're currently in August of 2023. So the next step is for the department to propose the rules to the Water Resources Commission at the Water Resources Commission at the end of September. And then the Water Resources Commission will likely adopt those rules. So what do the rules do and how do they do it? So the critical groundwater area designation and the Division 10 rules provide a framework for designating a critical groundwater area and then going through the contested case process to restrict groundwater use. So that first step really is a critical groundwater area is designated in the basin program rules through a rulemaking. And the second step is that groundwater use is restricted through an order after a contested case process. So this two-phase approach is long and can be fairly complicated. So I'm now going to go through and break down the two phases here, and they will talk about what each phase does and how it's implemented. So phase one is designating a critical groundwater area by rule. So in order to designate a critical groundwater area under the statutes, which is ORS 537-730, one of the following 7 conditions must be met. So the groundwater supply must be overdrawn or about to be overdrawn. Groundwater levels are declining excessively or excessively declined. There has to be a pattern of substantial interference between wells. There could be a pattern of substantial interference between senior surface water right holders and users of groundwater. There could be a pattern of interference related to geothermal resources. Groundwater temperatures are being extensively altered, or groundwater pollution is impacting public health. So these are the 7 criteria. If any one of these is met, then a critical groundwater area may be designated in rule. So a couple of definitions here that are really important is one is overdrawn. And the definition of overdrawn is that annual pumpage in any 1 year exceeds average annual recharge. The other definition that's important here is groundwater levels are declining excessively or are excessively declined. So declining excessively means that water levels are declining at a rate of 3 feet per year for 10 years. And excessively declined is defined as water levels having declined 50 feet below the highest known value. So now I'm going to break down the different steps in the rulemaking process for designating a critical groundwater area. And these steps are labeled A through G here in this diagram. So in the first step, step A, the department finds that an area of the state meets one of the criteria under ORS 537-730, 1A through G. So as we discussed, those are the 7 criteria that give the department and the Water Resources Commission the authority to designate a critical groundwater area. And this determination is often supported by a basin study, but it could also be supported through work of the department in a basin. Step B is when the rule drafting begins, and there are a number of components within step B. And in step B, the department's going to begin to draft those critical groundwater rules and the basin program rules. This is where the rule language begins to form. And Division 10 provides specific requirements for what's in this rule content. So the rules must include and define the boundaries for the critical groundwater area. The rules must also include provisions for periodic review, and the rules may contain corrective control provisions. So these are the 3 things that have to be included in the rules, and now we'll talk about each one of them. So how can a boundary be defined? In rule, we say that a boundary can be defined either according to the presence of physical natural boundaries, hydrological conditions, or recharge or discharge areas. So those would be the physical features in an area. And secondly, it could be defined administratively by defining an affected area that does not have boundaries defined by natural features. So the 2 pair together to allow for an effective, the creation of an effective boundary for administering and managing groundwater within an area. So the draft rules must also include a provision requiring the review of conditions within the critical groundwater area at least once every 10 years. So this means we have to check on and update our understanding of the conditions within the area at least once every 10 years. And If there is a provision in the rules that is going to limit groundwater use, then we have to review the rules at least once every 3 years. And so the draft rules must also include this provision requiring that review every 3 years. So the last piece is the corrective control provisions that can be allowed, or that can be used in rule. And so these corrective controls that could be outlined in the draft rules are listed here. And these are authorized specifically on ORS 537-735. And of these, we have a provision closing the critical groundwater area to any further appropriation. So this what allows the department to essentially say no further groundwater permits are going to be issued. And it allows the department to refuse any applications for groundwater permits within that critical groundwater area. The second thing is a provision determining the permissible total withdrawal of groundwater in the critical area each day, month, or year. So this is essentially how much groundwater pumping is going to be allowed in the critical groundwater area based on some time period. The third item is the disposition of any application for a water right permit for the use of water in the area that is pending at the time the commission initiates the rulemaking process or that is received during the rulemaking process. So if water right permit applications come in during the rulemaking, the corrective control provision, this corrective control provision allows the department to decide how to handle that application, whether it's denied or allowed. The fourth item is any one or more provisions making such additional requirements as are necessary to protect the public health, welfare, and safety. And this is a fairly broad corrective control provision and allows for flexibility to meet the needs of the situation in the critical groundwater area. The fifth item is a provision closing all or part of the critical groundwater area to further appropriation for its thermal characteristics. And the last one is a provision determining the permissible change in thermal characteristics. So depending on how the thermal characteristics of the aquifer have been affected, this allows the department to decide how to address those potential challenges. So these are the corrective controls that could be put in the draft basin program rules designating a critical groundwater area. And this is, again, all part of that rule drafting process. So in step B, to support all this, there's an additional requirement, and that's in addition to drafting the rules, the department shall also draft a report to support the critical groundwater area designation process. So this report is going to contain the science and the information that is being used to support that designation and that has evaluated those criteria that allow and authorize the designation of the critical groundwater area. This report needs to occur prior to the RAC. That's the Rulemaking Advisory Committee that would be formed as part of this rulemaking process. And the department will post this report on its website. So this report is going to be a draft report posted on the department's website. And it's going to contain the following things. So the report is required to be based on the best available science, and it must identify the criteria met under ORS 537-731 A through G. So that's which one of the 7 criteria that allows and authorizes the designation of a critical groundwater area have been met. It needs to identify and characterize the groundwater reservoirs subject to the proposed critical groundwater designation. So this is essentially saying, okay, which aquifer, how big is it, where is it, and how is it going to be included in the designation. And then it needs to identify corrective control measures likely to resolve the problems that resulted in recommendation to designate a critical groundwater area. So essentially we have what's the problem, where is the problem occurring, and how do we fix it? And that's the intent of the report. So the report gets published on the department's website as a draft report, and then until the close of the public comment period, consistent with ORS 183-335. So that's essentially the rulemaking process. So while the rulemaking process is ongoing, the department will accept information and comments on the draft report from the public. So this provides the public with the opportunity to review the report, review all the information, and provide any additional information or comments on that report to the department. And then the department shall review the information and comments received and present a final report to the commission that includes the department's findings and conclusions and includes an assessment of the information and comments received. So essentially what this says is, after the public comment period has closed, the department is going to review the report, review all of the information and the comments provided by the public about the report, and then is going to provide a final report to the commission that is also going to contain an assessment of that additional information and comments received. So that concludes step C, and now we move step B, excuse me, and now we'll move on to step C, which is consultation with federally recognized tribes and coordination with affected local governments. So in step C, the department will consult with federally recognized Indian tribes about the proposed rules. And to facilitate this consultation, the department is going to provide the draft report that was created back in step B. At the same time, the department is also going to coordinate with affected local governments to ensure that the critical groundwater area designation is in line with land use planning goals. And again, to facilitate this coordination, the department is going to provide that same draft report from step B. Moving on, we then go to step D, in which a rules advisory committee is initiated. And so that RAC is going to be composed of members of the public and any potential stakeholders that would be affected by this rulemaking process and by the rules that would be adopted. So as part of this, the department will follow the rulemaking process as required by ORS 183, which is the Administrative Procedures Act. And so really this rulemaking process is following ORS 183. So in step E, in addition to the requirements under ORS 183-335, which outlines how the rule notification will work, the department is also going to notify the owners of record of all groundwater registrations, inchoate transfers, permits, and certificates for groundwater use within the affected area. So this essentially means all groundwater users within the affected area that are permitted or registered, certificated, or in transfer. The second group that the department is going to notify above and beyond the normal notification requirements is all tax lot owners within the affected area and that are not within a municipal or quasi-municipal water service area. So the intent of this is to make sure that all groundwater users all tax lot owners who are likely to be the groundwater users within an area are going to know about the rulemaking. And then the last one, the last group that will be notified is each well constructor licensed under ORS 537-747. So this is essentially all of the licensed well constructors in the state, because they need to understand that there's a rulemaking going on that was going to potentially designate a critical groundwater area. So next, step F, we'll have at least 60 days after the notice of proposed rules, the department must hold at least one public hearing in the affected area. So this allows for step F, the public comment period, it's going to include also a public hearing in which members of the public can come out and provide oral comment on the rules, as well as during the public comment period, anyone may provide comment in written form on the rules. So the last step is that the rules would be adopted. And so the Water Resources Commission will meet, the rules will be presented to them, and they will adopt those rules. And if they adopt the rules will then be filed with the Secretary of State. And the second piece is that the rules must be filed with the county clerk of each county within which any part of the critical groundwater area lies. So this means that if a critical groundwater area crosses county borders and exists in potentially 2 or more counties, then all of the county clerks for each of the counties in which that critical groundwater area exists will be notified and provided with a copy of the rules. So that concludes phase 1, designating the critical groundwater area in the basin program rules. So that establishes the critical groundwater area. Now, in order to actually implement any sort of regulatory control to restrict groundwater use, the department must go through phase 2, which is issuing an order and then taking that order through the contested case process. Again, we have a number of steps that we have to go through in order to get through this process and get to actual action. And here we go through steps A through K. So the first step, step A, is an initiation of a contested case. And to initiate that contested case, we have to have a draft corrective control order. And that draft corrective control order can contain any of the following provisions. And these provisions are authorized in 536, ORS 536.735. So those corrective control orders and corrective control provisions within that order include a provision apportioning the permissible total withdrawal as established by rule to the different appropriators of groundwater that are holding valid groundwater rights in the critical groundwater area. So essentially what this means is in rule, we have set up a total allowable pumpage, right? A permissible total withdrawal. And this provision is then in an order actually assigning that permissible total withdrawal out to the valid water right holders and who is going to actually receive the ability or the authorization to use water. The second corrective control provision that can be in rule, sorry, in a draft order is a provision according preference without reference to relative priorities to withdrawals of groundwater in the critical groundwater area for residential and livestock watering purposes first. And then it goes into even more detail about what other uses could be authorized. But this allows the commission through the draft order to provide preference to livestock watering and residential uses first without regard to the system of prior appropriation. And so this essentially allows the commission to decide that livestock and residential uses, human uses, are more important than other uses, and therefore they can accord preference in water use to those specific items. So then the third provision that could be in the draft order is where 2 or more wells in the critical area are used by the same appropriator, a provision adjusting the permissible total withdrawal of groundwater by such an appropriator, or a provision forbidding the use of 1 or more of such wells completely. So essentially, the order can designate which wells a groundwater user gets to use and can restrict the use of 1 or more wells completely. The fourth provision that could be in a draft order is a provision requiring the abatement in whole or part where the sealing of any well in the critical area responsible for the admission of polluting materials in the groundwater supply, or responsible for the progressive impairment of the quality of the groundwater. So this provision here specifically allows the department to look at well construction and to fix any well, require the fixing of any well that is contributing to a groundwater pollution problem. And then the final provision that could be in a draft order is a provision requiring and specifying a system of rotation of use of groundwater in the critical area. And so this provision essentially says the commission through an order could specify that groundwater users use water in a system of rotation. So potentially one user uses groundwater for a period of time, and then the next groundwater user uses groundwater for a period of time, and the next, and so on. And so that's the final provision that's allowed in a draft order. So once the draft order is prepared, we then have to prepare an initial notification of proposed corrective control orders, and then we have to deliver that initial notification of proposed corrective control orders. So this is how we essentially let the affected parties and the public know that there is a notification of proposed corrective control orders, essentially a draft order coming. So as I said, this document serves as the notification that OWRD will be sending an order, and it's going to contain preliminary information about that order. So it's going to contain a list of the proposed corrective control provisions. It's going to contain a statement describing the factors for the critical groundwater area designation. It's going to contain a description of the geographical area, and it's going to explain how a non-groundwater user can request the order. So how is it going to be delivered? So first class mail is going to be used to send the initial notification of corrective control orders to affected local governments, federally recognized Indian tribes, and property owners of tax lots within the critical groundwater area. It's also going to be published in the OWRD weekly bulletin for 4 weeks, on the OWRD website, and in the local newspaper for 2 weeks. And last, it's going to be announced through a public meeting held in the critical groundwater area. So 3 different methods by which the initial notification will be sent out, with the hope of notifying as many people as possible and making sure those potentially affected by the order know that it is coming. So then we move on to steps D and E, and that's the preparation of the notification of proposed corrective control orders and the delivery of that notice of proposed corrective control orders. So that essentially what this step is, that first step was, hey, we're saying, hey, this is coming. And now here we're actually sending out that draft order. So this document is going to serve as that draft order. It's going to contain the following information, essentially who is involved, what geographic area or sub-area is impacted, what is being proposed. So again, those corrective control provisions. It's going to include the scientific information supporting the action or references to that scientific information. It's going to contain the reasoning for the action. And then it's going to contain a notice of the right to a contested case hearing. And it's going to contain deadlines for submitting a request for hearing and or petition for party status. So how are we going to send out this notification of corrective control orders, or essentially the draft order? There are multiple methods. So first is by certified or registered mail to the groundwater right holders in the affected area and the exempt users whose groundwater use would be limited by the order. So certified mail to the people who are directly impacted by the order. By regular mail or email to persons who have requested copies of the order and chose their preferred contact method. So as part of the initial notification, non-groundwater users or people who are not going to be affected by the order have the ability to request this notification of corrective control orders. And when they do that, they have the option to either request notification via regular mail or via email. And whichever they choose, we will then use that preferred contact method to notify them. And then the last is that the notification of corrective control orders will be published on the OWRD website and in the OWRD weekly bulletin for 4 weeks. So again, the hope is to get this notification of corrective control orders into the hands of the people who are affected by it and into the hands of the people who requested it, and also make it available to the general public for review. So now we move on to steps F, G, and H. In step F, we're allowing interested parties to file for party status or to file a request for hearing. And then in step G, we're going to consider all of those petitions for party status. And then in step H, the director is going to prepare a list of issues, and then we're going to forward that on to the Office of Administrative Hearings to actually conduct the contested case. So now I'm going to walk through a flow chart of steps F, G, and H for the purposes of trying to make this process even more clear. So when the notice of proposed corrective control orders is mailed out by the Oregon Water Resources Department, as I said, it's going to go to groundwater rights holders and exempt users whose groundwater use will be limited. And that's on the green side of this flow chart. And when they receive that, they then have the option to file a request for hearing by the deadline outlined in the notice of corrective control orders. And so they can submit that request for hearing, and WRD will receive that request, and then they will hold those requests together to be prepared and forwarded over to the Office of Administrative Hearings when we get to that point. At the same time, anyone who requested a copy of the notice, as we said they could do, either via mail or email, will then have the option to file a petition for party status. So if they believe that they should be party to the contested case hearing for whatever reason, they can file this petition for party status by our deadline, or they could file after the deadline with good cause justification. And either way, if they file that petition, WRD then has to serve that petition on all parties to the proceeding. So that means all the groundwater right holders and exempt users whose groundwater use would be limited. So the people on the green side of the flow chart are going to get a copy of that petition for party status. So at that point, then all of the parties, again, the people in green, groundwater right holders and exempt users, have the option to respond within 7 days of service, and they can respond with their comments about whether or not they believe the parties should be permitted party status. And then after that, WRD can either grant the petition or deny the petition. If the petition is denied, then a petition to reconsider could be filed. If it's approved and party status is granted, then the department is allowed to specify the areas of participation in the hearing and any procedural limitations on that party within the contested case hearing. So at that point, WRD is going to write orders on party status, and it's going to serve that on all the petitioners and the parties. So the person who petitioned for party status will receive this order, and all the parties, again, the people in green, the groundwater right holders and exempt users whose groundwater use will be limited, would receive a copy of the order on party status. So once all that's done, WRD is going to refer the matter to the Office of Administrative Hearings. And as part of that process of referring the matter, the director of the department is going to put together a list of issues that will be contained within the contested case hearing and will be essentially the issues at hand in that contested case hearing. So now we're going to move on to steps I and J. And in step I and J, the contested case hearing is conducted. This process is primarily governed by OAR 137-003-0501 through 0700. So essentially, the contested case hearing process follows other Oregon administrative rules about how it's conducted. There can be some exceptions, and those exceptions are noted in the Division 10 rules. Those exceptions can include some additional requirements, like, for instance, the department must post the information contained in its referral to the WRD website, and that information would be information that supports or is relevant to the notice of proposed corrective control orders. So then the contested case hearing is actually going to be conducted by an administrative law judge. And once the hearing is concluded, the administrative law judge is going to issue a proposed order. And any exceptions to the proposed order must be filed within 60 days. And the commission must consider all timely filed exceptions. So essentially, if any of the parties in the case disagree with the proposed order, they could file an exception, and that the commission must review those and consider those timely filed exceptions. So then, after the commission has reviewed that proposed order, those timely filed exceptions, we get to step K, which is the final step, in which final order is actually issued. And that final order is then going to be enforced to manage groundwater use within the critical groundwater area. And that then concludes phase 2, which is the actual implementation of corrective controls through an order. So the last piece of Division 10 are rules that outline how to modify existing critical groundwater areas. So there are currently 7 critical groundwater areas in Oregon. This map shows those 7 in red. These areas were all designated under previous versions of the Division 10 rules. So they were established under old mechanisms, and any new critical groundwater areas would be established under these new Division 10 rules. So the Division 10 rules that are proposed for the Commission to adopt give the Water Resources Department the capability to modify the designation based on the best available science. And so the reasons the department needs to be able to modify critical groundwater areas are listed here. And they include that new data could suggest that boundaries of the critical groundwater area or a subarea may need to be adjusted. So there may be additional scientific evidence that comes out that says we should change the boundary of a critical groundwater area. It's also possible that the original permissible total withdrawal may need adjusting. So we need to be able to adaptively manage. Management of those groundwater reservoirs, as I said, needs to be adaptive and flexible to changing conditions. As precipitation or climate changes, recharge potentially changes, we may need to change our critical groundwater area designation and the rules therein to be adaptive and flexible. And then last, there are 2 early critical groundwater areas that were established that require significant staff time to allocate groundwater annually to senior users. And the department is really interested in modernizing the allocation process to reduce staff workload and provide more certainty to water users. And so these are the key reasons why the department needs to be able to modify not only existing critical groundwater areas, like existing today, but in the future, critical groundwater areas that have been established under these new rules also need to be, may need to be modified. And so the department needs that ability and that flexibility. So thank you for taking the time to listen to this presentation on the Division 10 critical groundwater area rules. Hopefully this is helpful and provides you with the information you need to understand our rules update. Thank you.